Good morning, everyone, and welcome. We're very pleased to have you with us today. Today we have a one-case docket specially set for this case, and that afforded us the opportunity to extend additional time for the attorneys to present their arguments and for us to ask questions. Each side has a total of 30 minutes to argue, and that applies whether there's one or multiple attorneys arguing from that perspective. If you are sharing time, you'll have to let us know how much to allocate so that the clock can be programmed accordingly. The appellant has the right to reserve some time for rebuttal, so if you would, let us know at the beginning of your argument and the clock can be programmed accordingly. We're pleased to have representatives of the media with us today, and I want to thank the two television stations for agreeing to pool their coverage so that we would have one camera in the room instead of multiple. We have approved another representative of the media to make his own personal recording of the arguments today, which I understand is mainly to assure that his recollection is correct, he or she, when the article is written. We're pleased to oblige in that regard as well. Are there any announcements or introductions? Hearing none, please call the case.
Mayor Lee Harris et al. Versus Governor Bill Lee et al.
Good morning.
Good morning. Thank you, Your Honor, and may it please the court, Matt Rice, on behalf of the state, I'd like to reserve 6 minutes for rebuttal.
6 minutes, thank you.
Yes, sir. In September 2025, Memphis was the most violent city in the country. So the governor took action. He mobilized the National Guard as a part of the Memphis Safe Task Force. That mobilization falls squarely within the governor's statutory authorization and his constitutional authority as the state's commander-in-chief.
Is there any document that reflects that, or was it done orally?
There is no written document, Your Honor. There is no written order from the governor. But we do think that the governor's deployment here falls within the scope of his statutory and constitutional authority, and we think that the district court made 3 independent legal errors. 1, sovereign immunity, 2, standing, and 3, the merits. And let me start with sovereign immunity because I think that is the simplest way for this court to reverse the Chancery Court. So the state and state officials are generally protected by sovereign immunity. Now that immunity can be waived, and it has been waived for certain claims in section 13121.
But do we really need to get into 13121 here? And if we think about Colonial Pipeline, isn't this, at least with regard to the constitutional claim, let me separate out the constitutional claim and the statutory claim here, but at least with regard to the constitutional claim, if all that's being sought here is a prospective injunctive relief, aren't we outside the bounds of sovereign immunity?
I don't think so, Your Honor, and let me explain why. The Colonial Pipeline case did say that sovereign immunity does not bar a declaratory judgment or injunctive relief against the state to prevent the enforcement of an unconstitutional statute. But it said that that exception only pertains to suits preventing the enforcement of an unconstitutional statute. The plaintiffs here have not challenged the constitutionality of 106A. And Your Honor, to the extent
wasn't the interpretation, though, of Stockton that appears within Colonial Pipeline broader than that in terms of the idea that if you're enforcing an unconstitutional action and all that's being sought is an injunction against it, prospective relief, that Stockton, even before Colonial Pipeline, would say sovereign immunity doesn't apply?
Well, Your Honor, I do think that, I think we agree that there is an important role that is played by Colonial Pipeline, but I think where we disagree is that we don't think they can have it both ways. We don't think they can both claim that Colonial Pipeline applies and they get around sovereign immunity through Colonial Pipeline, and also evade the 3-judge panel statute. So it can't, either this case needed to go to a 3-judge panel, or...
Why would the rationale of Colonial Pipeline be any different if you were talking about an unconstitutional executive action, and both sides seem to agree that this is an executive action, not an executive order that we're talking about here. Why is the rationale of Colonial Pipeline any different if you're challenging the constitutionality of some executive action as opposed to a statute?
Well, Your Honor, I think that the reasoning of Colonial Pipeline was that when you have an executive that is enforcing an unconstitutional statute, we're going to create a legal fiction, essentially, that says that you are not actually suing that official in their official capacity. You're suing them as an individual, and thus we don't think sovereign immunity applies. I think Colonial Pipeline put limits on that waiver of sovereign immunity to the challenging of the constitutionality of a statute. And again, if they want to challenge the constitutionality of the statute, we think this should have gone to a 3-judge panel, Your Honor. And I think that's our point, is that they can't have it both ways. They can't come to this court and say, oh, well, we're not challenging the constitutionality of a statute and claiming that this statute that you invoked is unconstitutional, and avoid the 3-judge panel.
There are some cases from 2016 that are unpublished from this court that have looked at Colonial Pipeline in light of a statutory challenge, not a constitutional challenge, but an argument that the action was not in accord with statutory requirements by the executive. Is there a published decision of either this court or the Tennessee Supreme Court post-Colonial Pipeline that would preclude application of the Colonial Pipeline rationale to a statutory challenge? I want to give you a sense of where I'm coming at with this. I'm struggling to see why sovereign immunity is really implicated at all in this case. And you have a case in which there's no attempt to gain money from the Treasury. It's not a dollars and cents suit. It's an allegation that this is unconstitutional action or illegal action, and seeking prospective injunctive relief. So why are we in the world of sovereign immunity at all?
Well, Your Honor, I do think that the Colonial Pipeline decision has been limited to constitutional challenges and not statutory challenges.
Is there a published case that says that, post-Colonial Pipeline?
Not that I know of, Your Honor, but if I could just read from Colonial Pipeline, it says that this exception to sovereign immunity, quote, pertains only to suits preventing the enforcement of an unconstitutional statute. So that's directly from Colonial Pipeline itself, Your Honor. We do think that sovereign immunity does play a role here, and we think that there is no colorable argument that the word person includes the sovereign. The natural meaning of the word person does not refer to governmental entities. There is a long-standing presumption that the word person does not include the government. That is reflected in the U.S. Supreme Court's decision in Return Mail. And when the General Assembly intends to include the government within the scope of the word person, it does so expressly. It's done so repeatedly in a number of statutes, and it did not do so here. The Supreme Court faced a similar situation in the Moreno case, and it declined to read the word person in Moreno to include a governmental entity. If there are no further questions on sovereign immunity, I would like to turn to standing.
Actually, I do have a question.
Yes, Your Honor.
The caption of the bill that became 13121 says that it's an act to amend Tennessee Code Annotated Title I, Chapter 3, relative to private rights of action. When captions can be used to interpret what statutes mean or aid the interpretation, does that interpretation, do the words private, relative to private rights of action, support your theory of how to interpret the statute?
Your Honor, I don't know that it cuts either for or against I think our theory. Private rights of action, I mean, I guess you could say that it's a public right of action if you're suing on behalf of a governmental entity. I think the whole purpose of 13121, though, was to clarify that there was a cause of action to bring these types of suits. We haven't relied on the caption. We think the plain text and the meaning of the word person clearly cuts in our favor, and there's not too much of a textual argument here. We think, particularly in light of the clear statement rule, which requires clear, plain, and unmistakable terms before the court finds a waiver of sovereign immunity. We don't think that clear waiver has been made with respect to governmental entities. Your Honor, we do think that whatever the court thinks about sovereign immunity, we do think that the plaintiffs here lack standing. They assert a generalized loss of political power that federal and state courts have repeatedly rejected as a basis for standing, including the U.S. Supreme Court in the Raines decision. State and local legislatures, their arguments fail for a couple reasons. One, the legislative plaintiffs suffered no cognizable injury. They essentially argue that any time that the executive acts outside of his constitutional or statutory bounds, that they have suffered an injury and that they can bring suit. No case law supports that proposition, and the implications of that are staggering. If, as Judge Usman referred to, that there's a waiver of sovereign immunity for prospective relief, statutory or constitutional, as alluded to, that means that any time an individual legislator thinks that anyone in the executive acts outside of the scope of their authority, they can bring a lawsuit. That is a staggering position, and that is going to overrun the courts with political fights.
In thinking about Mayor Harris here, and I want to distinguish the mayor here from the legislative standing based challenges. The real party, if somebody sues Mayor Harris tomorrow, the real party in interest in that suit, if it's a suit against him in his official capacity, is the city of Memphis, right? I mean, that would be the real party of interest in any litigation against him. Does it work the same way if it is Mayor Harris suing? Is it essentially Memphis suing, or is that something different if he is the plaintiff rather than the party being sued?
We think it's very different, Your Honor. And we think that the Supreme Court said it was very different in the Fannin case, that's the Tennessee Supreme Court case, where a individual legislator brought suit purporting to allege some loss of political power. And the Tennessee Supreme Court said, you cannot sue on behalf of the locality. You lack that authority.
Is that different, though, than when we're talking about the mayor versus, and that's one of the reasons I want to separate out Mayor Harris from the legislative plaintiffs in this case. And this case is Harris versus Lee. It's not state of Tennessee. And isn't this the stand-in here? Mayor Harris is effectively the city of Memphis. So the injury that we should be thinking about is, has Memphis suffered some kind of injury for purposes of standing?
I don't think so, Your Honor. I don't think so. One, because there's nothing in the Shelby County Charter that authorizes the mayor to sue on behalf of the entity, and that is what Fannin latched onto. The Tennessee Supreme Court pointed out that this individual legislator was not authorized to sue on behalf of the county. And you don't have to take my word for it. Their response brief says that Mayor Harris, quote, is not purporting to proceed on behalf of Shelby County. That is from their brief. So I don't think that all of these injuries that they're pointing to with respect to reputational harm, operational cost, et cetera, all of those are injuries tied to the county. And if the county wants to vindicate those interests, the county has to sue, or it has to delegate its authority to sue to the mayor. The county has not done so, and they have admitted that they are not proceeding on behalf of Shelby County. So the mayor has to show an injury specific to him, his office, and he has not made that showing. There's no evidence of diverted mayoral resources or interference with executive duties, and even if there were, the mayor's voluntary diversion of his time is not a justiciable injury. That the mayor may choose to spend more time on TV or doing interviews or going to press conferences rather than governing is not a justiciable injury. And the Supreme Court said so in FDA versus Alliance for Hippocratic Medicine. And I also think, Your Honor, there's a prospective, retrospective problem here because, as Your Honor pointed out, they're seeking prospective relief here. Well, if the mayor is seeking prospective relief, then he has to show a prospective injury. That certainly has not been shown here. And I would, for this prospective versus retrospective and how that fits into the standing analysis, I would direct this court to NAACP versus Lee, 105 F 4th 888. Your Honor, turning to the merits, the plaintiffs here have not carried their burden of showing that the governor acted outside of his statutory authority to mobilize the Guard. Section 58-1-106A authorizes mobilization for a grave emergency, and the situation in Memphis was a grave emergency. Contemporaneous dictionary definitions defined emergency as a pressing need or a relatively permanent condition of insufficiency, and that describes the situation in Memphis. At the time of the mobilization, Memphis was the most dangerous city in the country by a wide margin. The murder and violent crime rate...
Memphis has had a history of issues with crime, and significant crime issues, and you can look back to State v. Banks in 2008, and the Tennessee Supreme Court recognized that the murder rate in Memphis was essentially, a third of all murders and 12% of the population. This is not necessarily a great American city, but that has had a crime problem for some years. For a grave emergency, does there have to be some change or alteration? Does it have to be something that there's suddenly arising or significant alteration in the level of the problem?
We don't think so, Your Honor, but we think we satisfy that either way. And let me start with the former. Plaintiffs get this kind of sudden condition or this sudden attachment with respect to emergency by cherry picking from a 2024 dictionary that is nearly half a century after the enacted statutory language. They have pointed to no dictionary definition that includes that type of suddenness condition that is contemporaneous with the passage of the statute. I guess another point is we think that 106A and the other items in 106A refute the notion that there's a suddenness requirement. So if you think about disasters, for perhaps a wildfire or a drought, these are things that sometimes they get worse and worse and worse and worse, and to the point where they become a grave emergency. They may not have been a grave emergency immediately. There may have not been a sudden change. It's just the persistent worsening of events leads it to become a disaster.
Does it have to have an end? And crime is a perpetual problem throughout human history. And there's this surge in Memphis. There's going to be a crime problem in every state, not just Memphis, but every city across the state of Tennessee. They're continuing crime issues. Does there have to be an end for something to be an emergency?
Well, I think there has to be an end by statute. I mean, the statute in 106B says that the mobilization of the National Guard can only endure and to the point for the duration of the emergency. To the extent that Your Honor is asking whether we think that all crime is an emergency, that is not our position. Our position is that that having the most violent city in the country, which is a stark contrast from even the second closest city, is 345% of the national average, and 4 times more violent than Mexico City, we think that that qualifies as a grave emergency. And to the extent Your Honor thinks that the concept of an emergency has to have some suddenness or some change, we still think we satisfy that standard, because what happened was in 2024, crime throughout the entire rest of the country was going down, and crime in Memphis was going up. I think that is an emergent condition that would have justified the deployment of the National Guard. Your Honor.
John, would you agree with me that in thinking about separation of powers related issues, there's issues that are in that ballpark, that courts in this country have long looked at legislative action and inaction as part of the assessment of whether executive action was within the scope of the authority of a governor or the president? And I'm thinking about cases like the prize cases, right, of the 1860s, with Congress coming in and blessing President Lincoln's actions in blockading the ports. And is it a fair statement to say that legislative inaction has come into the mix? I'm not saying it's determinative, but come into the mix in separation of powers issues?
Your Honor, I mean, I guess it could be used as a tool. I don't think it can override the plain text. And so if the text can be read to include something, I don't think...
Should we consider it here? And so this operation started, and it's authorized in mid-September, and we're sitting here in March. Has the General Assembly taken any action? This is a major public policy issue in the state of Tennessee. Have the lawmakers of the state taken any action to embrace the governor's actions here?
Well, Your Honor, I think a couple points on that. One, this identical argument got opposing counsel yelled at last week or a couple weeks ago in the airport authority argument. But second of all, there has been no action because there has been a say. And so I don't know how much this court can read into this about the legislature condoning or not condoning. I think if Your Honor wants to look outside of the record, there are plenty of news articles showing that they were prepared to take action statutorily, but that there was a stay that prevented that from happening.
Well, and nothing prevented the legislature from acting, right? And the legislature could have adopted, and one of the disputes in this case, right, is whether the language in subsection C, if it's not in A, and if the legislature adopted that language and incorporated it into A, then at least with regard to the statutory issue, that's off the table.
I think that's a dangerous way to engage in statutory interpretation, Your Honor, is to speculate about what the legislature could or could not have done. I think the legislature...
So we shouldn't consider inaction here.
Certainly not here. Inaction in response to a Chancery Court decision that was stayed.
In terms of the governor's action, and the governor has called up the National Guard, and the legislature has not weighed in, as far as I know, at least with regard to any sort of enactments to embrace the governor's action.
I mean, to the extent I think that the legislative enactment shows anything, it shows that the governor is acting within the authority that the legislature thought that it granted to him, and that he has continued to exercise. I mean, the legislature could have just as well restricted the authority in response to the Chancery Court, but it didn't do so.
So it's purely neutral in this case.
I don't see how it could affect this case, and I don't see how it can affect the plain meaning of grave emergency. And if the most violent city in the country is not a grave emergency, I really don't know what is.
The plaintiffs in this case argue that the governor should have proceeded under 106C instead, going through the city or county legislature. But C is labeled by the legislature as an alternative and cumulative procedure. So does that not mean that the legislature viewed imminent danger of crime and a breakdown of law and order as encompassed in A as well?
Your Honor, I think that it viewed these as alternative pathways for
the same result.
For the initiation of the guard. I do think there are. It didn't want these triggers necessarily to be mutually exclusive. The separate pathways that were set out, they come with different funding obligations. For example, if 106C is used, then the locality is on the hook to pay for that. The locality does not have to pay under 106A. But I would like to address, Your Honor, their argument with respect. They're pointing to 106C as an attempt to limit 106A because we don't think that argument works. Their position, I'm going to quote, "Whatever else subsection A encompasses, it does not reach breakdowns of law and order." But that can't be right because insurrections and riots often involve breakdowns of law and order. So under plaintiff's position, the legislature granted the governor the authority to mobilize the National Guard for a riot, but not if the riot involves a breakdown of law and order, or an insurrection, but not if the insurrection involves a breakdown of law and order. That's not using structure to interpret the statute. That's using structure to add an atextual limit onto the statute. And if the governor can activate for a riot or an insurrection that involves a breakdown of law and order, he can activate for a grave emergency that involves a breakdown of law and order. So we think that their structural argument tries to do too much. We do think it's telling that they actually don't lead with their alternative definition from a 2024 dictionary that points to suddenness. Their frontline crux argument is the structural argument that the court should graft on a carve-out to 106A of all breakdowns of law and order. I don't think it works. Another example, combination to oppose the enforcement of the law. So I guess if that combination were in fact successful, and it opposed the enforcement of the law, then the governor couldn't deploy because there had been a breakdown of law and order.
General, wouldn't your reading, though, of combination essentially allow for any conspiracy to allow the governor to call in the National Guard? And how would we possibly distinguish, given how you're defining the combination, and any conspiracy action within a city becomes a basis for the National Guard coming in?
I disagree with that, Your Honor. One, I think no one disagrees that gangs are combinations. No one also disagrees that they oppose the enforcement of law by force and violence. The only question is whether they are combinations to oppose the enforcement of law. Our position is not that all criminal conspiracies are combinations, it's that the gangs in Memphis are. And I think that plaintiffs provide a sanitized view of how gangs operate. Gangs don't just go around and try to deal drugs and avoid law enforcement. They take over particular territories, neighborhoods, streets, and they replace government authority for gang authority. That's why turf wars are so so violent, because it's not about, oh, well, we're trying to sell drugs and we're just trying to avoid the police. No, they are taking over particular neighborhoods. I think that's reflected by the fact that gangs provide protection for businesses, protection that would have been provided by the government, and they deter cooperation with law enforcement. So I think that gangs, by definition, or at least the gangs in Memphis, maybe not all gangs, maybe if there's a gang of 3 people and they're not taking over neighborhoods, maybe that wouldn't fall within the scope. But the gangs in Memphis that are very territorial and that take over neighborhoods, those are combinations to oppose the enforcement of law, and this court could hold as much without opening the door for a flood of every time there's a criminal conspiracy that is necessarily a combination to oppose the enforcement of the law.
On the constitutional issue in this case, would you agree that in the 1870s, was the Tennessee Guard, was it a militia in the 1870s and became not a militia in the 1930s? At what point did the National Guard become not a militia? Was it not from the beginning, or?
No, I think the Brownlow era Guard was clearly a militia. If you look at the history, the dissertation that we cite, it's 300 pages, it's quite long, but it's very informative. I think our conception of militia is a group of forces that are they're a temporary force that is activated for a specific purpose. That's exactly how the Brownlow era Guard worked. In 1867, they compiled this state guard to ensure that the radicals and the freedmen could vote in safety. And then it completely disbanded. In 1868, the Guard was not called out at all, and the Klan took over the election. So they reassembled the Guard in 1869. So we think that the Brownlow era State Guard was clearly a militia. We think that's very different from what we have here, because we have a perpetual force that is run by permanent officers. There are over 2,000 permanent guardsmen that are in uniform every day. That looks nothing like the traditional concept of militia. I see that I'm over on my time.
All right, thank you, General. We'll hear from you on rebuttal. Good morning, sir.
Good morning, Your Honor. Thank you, Your Honors, and may it please the Court. Joshua Salzman from Democracy Forward Foundation, on behalf of the plaintiffs. The Chancery Court correctly concluded that the governor did not have virtually limitless authority to send armed troops wherever and whenever he wants, for as long as he wants. On the contrary, the people of Tennessee have consciously withheld such potentially tyrannical powers from the governor. The deployment to Memphis is illegal twice over. First, as was just discussed, there is a statutory limit in that the cited basis of authority, 58.106A, authorizes deployments under only certain enumerated circumstances, none of which includes routine law enforcement. If more were needed, the Tennessee Constitution clearly bars deployments of the militia for unilaterally by the governor, and it is quite clear from, for example, the Supreme Court's decision in Perpich that the Tennessee National Guard, like the National Guard of every state, is a component of the militia. Given the blatant illegality of the deployment,
given the federal actions beginning in the turn of the last century and continuing in 1916 and 1933, don't those actions really transform the National Guard into an army, just like the state law calls it an army now?
No, absolutely not, Your Honor, and I point to a couple of things as to why that's not true. First of all, the Supreme Court in the Perpich case in the 1980s said that they are, in fact, a component of militia.
In Perpich, they were talking about the part that says it's the militia. They were talking about what the district court said, weren't they?
No, I think that they were providing context and reviewing overall the evolution of the National Guard, and they were explaining that up through the present day, the state National Guards are a component of the militia, and that's actually expressed in federal law. If you look at 10 U.S.C. 246, it expressly says that the National Guards of the states are the, quote, organized militia of the different states.
It says militia of the United States. It doesn't say the militia of the states, does it?
So I do think Perpich does say that the National Guards of the states are militia, that people who are in the militia have, I think in the words of Perpich, 3 hats. They have their civilian hats, which is their normal jobs when they're not called into duty. They have their militia hats that they wear when they are when they are doing their state service, and then there is also their Army hat when they are activated into the federal Army.
So your position is this is a militia and you can't call out the militia except for rebellion or invasion?
That's what the Tennessee Constitution says, and that's what
So
Attorney
we
General...
can't call out the National Guard to cut tree branches and free up roads after an ice storm. We can't call out the National Guard to help with COVID or with floods, or to recently the National Guard rescued a hiker in the Great Smoky Mountains. All that's illegal.
Not necessarily, Your Honor. I
Well,
don't think that
wait a
follows
minute.
from my...
You said you can't have the National Guard do anything but deal with rebellions and invasions. So all this other stuff would be out the window, would it not?
I don't think it necessarily would. I'm not taking a position either way, but the defining characteristic of a militia is that it is an armed, people who are primarily civilians who are called into military service. Staffing a call center during COVID, maybe that is would nonetheless, because the people staffing that call center belong to the Guard.
Going
Yes.
back to the first Constitution of the state of Tennessee, there's been this distinction between Army, Navy, and militia. If the National Guard is the militia, what's the Army? And because Tennessee has taken very seriously the idea that it has an Army and Navy, or that there's an Army, Navy, and militia role, what is the Army?
So remember that Constitution was adopted in 1796 against the backdrop of a federal constitution that in Article 1, Section 10 precludes states from having armies except when specifically authorized by Congress or during war or threat of
Congress
imminent
has
invasion.
authorized an army or the troops to stay in Tennessee, and that's the National Guard.
No, it's not, Your Honor.
Yes, it is. That's what the statute says.
No, the statute references the National Guard and then authorizes the states to organize a separate body called a state defense force. That's what that provision says. It does not, and that provision, by the way, postdates by many decades the establishment of the Tennessee National Guard. To return to the question of what is the Army, I think it's a body that is largely going to be dormant and to not exist except under certain specified circumstances, just as the state's Navy is not currently in existence, but if and when the state organizes a Navy because of an invasion or the like, then the governor would become commander-in-chief of the Navy. Just
So the
a few
militia
years
can
ago,
become the Army under your reading of the provision? It's, while dormant, it's a militia, but then it becomes active, it's an Army?
I'm saying that there is, for constitutional purposes, currently no Army of Tennessee. Tennessee can, for statutory purposes, define the National Guard as the Army, as it has in 58-1-104, but that doesn't mean that for constitutional purposes, that can't change the meaning of the Tennessee Constitution, which was, of course, adopted in 1870. In terms of...
But going back to the federal statutes, 32 U.S.C. 109A says National Guard or troops a state may maintain. And in time of peace, a state, the Commonwealth of Puerto Rico, the District of Columbia, Guam, or the Virgin Islands may maintain no troops other than its National Guard and defense forces authorized in another section. So the National Guard is authorized to be kept by the federal government.
It is, but I think the best reading of that is just for an avoidance of any confusion in the course of authorizing these national defense forces, Congress was making clear that it was not precluding states from maintaining their National Guard. But if you want to know what federal law says about this, it's quite clear from 10 U.S.C. 246 that Congress does regard National Guards as a militia. And I'd note that just 5 years ago, then Attorney General Herbert Slatery looked at this exact same question and concluded that, of course, the Tennessee National Guard is part of the militia, as various federal sources make clear.
Well, that's not binding on this court.
Of course it's not, but I think it helps provide important context.
Not even binding on the next Attorney General, is it?
No, it's not, Your Honor. But in terms of, let's turn instead to just what the meaning of the term militia was in 1870, because I think maybe that's what's going to be most helpful here. And if you look at that phrase, what it was understood to be were people who were civilians most of the time and soldiers only on occasion. You can find that definition, for example, in the United States Supreme Court's decision in United States versus Miller.
Isn't there a long-standing, under Tennessee law, though, isn't there a long-standing view of the militia as able-bodied persons 18 to 45? I mean, doesn't that go back to the 1700s?
Oh, absolutely, Your Honor. And to be clear, we are not saying that the National Guard comprises the entire militia. There has long been...
But isn't that how militia has been defined, as the able-bodied persons 18 to 45?
Well, you have components of the militia. For example, both federal law and the 1887 Militia Act of this state recognize that there could be an organized militia, the folks who enlist for regular training, and then the reserve or unorganized militia, which is the remaining reservoir of able-bodied potential soldiers. So the Tennessee National Guard, if you look at that 1887 statute, which is the first National Guard statute closest in time to the adoption of the 1870 Constitution, it says that the National Guard is a component of the militia. It's the organized component of the militia.
Today's National Guard isn't John Severe's National Guard.
It's not, but it has one crucial continuity. And what that crucial continuity is that the members of the Guard are primarily civilians. I'd point the court to page 1308 of the record, which is a declaration that the governor put in the Chancery Court. And it's explaining why it would be so disruptive if an injunction took effect immediately. And the upshot is it's because all of these Guards members have civilian jobs, and the specific phrase that it uses is that these individuals who enlisted in the Guard have, quote, put their professional lives on hold in order to come to Memphis. And that is the crucial distinction between a Guardsman, who is somebody who, like a traditional militia member, is somebody who is a civilian most of the time and a soldier only on occasion, as opposed to what was understood to be troops or members of an army under the classic definition, which are full-time soldiers.
Well, if we go back to classic ways the militia operated, didn't early militias elect their own officers? And is that done in the National Guard? I don't think so.
No, it isn't. There's, but I don't want to comment on whether or not Tennessee is following its own constitution in another respect. Article 8 does speak to the election of Guards. But if you want to go back to the earliest state statutes on this, I'd refer to the court to the 1836 statute, which the state cites on page 19 of its brief as an example of what a true militia looks like. And if you look at that statute, it is not a body that is called into existence and then dissolves, as Mr. Rice suggested. Rather, it suggests that there are regular units from different counties that have continuing numbers, like regimental numbers assigned to them. They have officers elected to tenures for 3 years. This was a continuing body with a superstructure of continuing organization.
Counselor,
that's always
I want to turn your attention towards the standing issue in this case. And I want to think through the plaintiffs in 3 categories with you. We have local legislative standing asserted. We have state legislative standing asserted, and then we have the mayor. And so I'm looking at the statutory provision here, and let's start with the local.
Yeah.
So 58.1.106C. I'm struggling to see the loss of a vote right by local officials, because C doesn't function as a veto, does it? I mean, the governor's acting under A, and where have the local legislative officials in this case been deprived of a right to vote? I mean, if they're going to have legislative standing, right? You can't walk into court and say, I think the action's illegal, therefore I have legislative standing. How have they been deprived of a right to vote or some other basis of legislative standing?
So the theory is that 106C constitutes a textual commitment to the local authorities, the local officials on the ground, the people best positioned to judge how the extent to which conditions have deteriorated. And it entrusts them with the responsibility for deciding by resolution.
Veto the governor's decision. I mean, let's say it's a riot. There's a corresponding one, right, under A and C. If the governor thinks the riot is bad enough that the National Guard should be called in, but local officials don't, local officials haven't lost any right to vote. And see, it seems to me that for your right to vote sort of theory to be applicable here, C has to function as a veto on A. And I'm struggling to see how C is a veto on A.
I don't think it needs to be a veto. What we need to be right about, and for purposes of standing, the court must assume we're right about, is that breakdown of law and order is a distinct category that is in C and necessarily absent from A. And
How is that possible when C is labeled as cumulative?
So cumulative means additive. It's an alternative procedure. We don't think that it's a veto. And I want to be clear about that. But what under normal principles of statutory interpretation, you assume the legislature acts intentionally when it uses a phrase in one place and not in another. So the fact that C includes that breakdown of law and order language that's absent from A should be given some significance. And the most logical application of it is exactly to the kind of case we have here, where the deployment is just for routine law enforcement. And that also is consistent with subsection B, which I heard Mr. Rice acknowledge imposes a time limit, not a number of days, but a conditional time limit, in that a deployment cannot last longer than the duration of the emergency. And if you're talking about something like law enforcement, which I think I heard the court earlier explain and recognize, I think quite correctly, is a continual need for any city, and particularly a major American city. If you read the emergency provision and allow it to be opened up to include everything, including regular law enforcement, it deprives the provision of all meaning and basically means the emergency might never end.
I want to tackle legislative standing in terms of state legislators. The vote here, what is the vote that's been deprived there? And there's a voting provision, right, in the event of rebellion, invasion, but nobody's asserting rebellion or invasion here. So what's the vote that state legislators have been deprived of their right?
The right to be involved in the decision over whether or not the militia.
But isn't that just back to the issue of whether this was illegal or not, whether the governor acted outside the scope of his authority? I'm struggling to separate the argument with regard to state legislatures from a general claim that the governor exceeded the scope of his authority. I mean, you could raise that in any case where you think the governor has exceeded the scope of his authority. You could say, I'm a legislator. I think he exceeded the scope. Therefore, I'm bringing suit.
Yeah, what I would say makes this different is Article 3, Section 5's textual commitment of the decision-making authority to the legislature. And that's why it's different from just a situation where there's a statute, the governor performs a function, and there's a fight over whether or not the governor acted within the bounds of his authority. It's that textual commitment. But I've noticed that the court has spoken about both groups of legislative plaintiffs. I do want to lead with, in some sense, what I think is the easiest basis for standing here, which is Mayor Harris, who's an executive official.
So in terms of thinking through this, if Mayor Harris is sued, the real party in interest is the city of Memphis. Does that function the other way? If Mayor Harris is suing, is the real party in interest, or the city, the county, the real party is the governmental entity, not the office, right? If he's being sued. Does it work the same way if he's suing?
I think to some extent, but I think the state goes too far in suggesting that it's really, he is just suing as the sovereign. What I think he is doing is trying to vindicate the prerogatives of his office. And he has, under the Shelby County Charter, he is the executive branch of Shelby County, all of the executive and administrative
authorities. Is he authorized to bring suits on behalf of the county?
He is certainly authorized to bring suit to vindicate the prerogatives of his office to the extent that they have been.
But is his office what suffered? I can see how Memphis and how Shelby County has suffered an injury for purposes of standing. I'm struggling to see how his office has suffered an injury for purposes of standing.
Well, I think, though, I'd urge the court to look at pages 100 to 102 of the record, which contain Mayor Harris's declaration. I think the cleanest example, though there are many in there, of the ways that his functions have been impeded is his explanation that he had set aside $18 million for anti-poverty grants that he had been expecting to be able to allocate for important functions, and that
Is that his injury, though, or is that the city's injury in terms of how the funding gets allocated, or the county's injury? I mean, it seems to me that we're enveloping him with injuries suffered by the governmental entity rather than the office itself, and that's problematic, I think, in terms of a basis for standing here.
I don't think so, Your Honor, and the reason for that is because as the executive branch of the government, he has prerogatives in his office, including as the chief financial officer and being responsible for the administration of Shelby County. His ability to perform
Could the county have brought the suit here? Could the county have brought this suit?
We certainly think so. I think that this would bleed a little into the sovereign immunity question about whether or not a governmental entity is qualifies as any person. We would say it does, but that's the only reason I hesitate here. But otherwise, from a standing purpose, I certainly think the county
Do you need
could.
13121 under Colonial Pipeline, or at least with regard to the constitutional challenge? I'll put the statutory to the side for a moment, but with regard to the constitutional challenge, do you really need 13121 to get you there? Doesn't Colonial Pipeline essentially allow you to seek prospective injunctive relief where you're not seeking monetary damages?
I think it probably does. The reason we think the court can and should resolve this on the basis of 13121, and I'm happy to sort of walk through in detail why that is applicable here. But it removes any doubt as to the statutory claim, and the other reason is because we were in federal court here, where the so-called Larson-Dugan doctrine applies, I think it would be quite clear that, which is the federal analog to Colonial Pipeline, it would be quite clear that it's not just about statutes, that other unconstitutional executive action would also be encompassed. Just given the fact that Colonial Pipeline does not, by its express terms, go that far, we thought it was more appropriate, especially given that we're bringing a statutory claim, to rely on 13121, which does apply here. And I want to sort of emphasize why that's true. That statute very broadly authorizes suit by any person. Now, everybody agrees that municipal corporations, offices, are sometimes persons for purposes of Tennessee law. The governor collects a few examples at 33 note 4 of his brief. I'd add one to the pile, which is a particularly pertinent one. The declaratory judgment statute says in 2914-101 that a municipal corporation is a person. Now, especially if you consult the legislative history, not that I think you even need to go there, it's quite clear that the effect and intent of 13121 was to make sure there was a mechanism for compelling state officials to follow the law because there had been ambiguity about the scope.
Well, is that dealing with private rights or public rights?
I think, especially if you consult the legislative history, it's quite clear it wasn't designed to distinguish between the two.
But the caption says private rights.
So what it was extending was building off of the declaratory judgment statute and making sure there was a mechanism for compelling the government to follow the law. I also think if you look to, for example, the federal analog, the Administrative Procedures Act, which in 5 U.S.C. 702 accomplishes something quite similar to 13121. It creates a cause of action and a waiver of sovereign immunity for people suing the government, suing the sovereign for injunctive or declaratory relief. And there, for example, the provision has been read quite broadly beyond there is a federal definition of person, and yet federal courts, the D.C. Circuit, for example, have not read it in a very limited or restrictive way. Rather, they've recognized that the purpose here was to provide a mechanism for entities, including sovereign states, to bring suit and vindicate their interests in making sure that the federal government follows the law.
Counsel, I want to pick up on a question that Judge Bennett asked you earlier and come back to this point. And so Judge Bennett raised the point about floods. He raised the point about tree removal after the ice storm. Would those, and I want to leave the militia constitutional aspect of this aside, purely statutory on 58.1.106A, all I'm talking about for purposes of this question. So does that fall within the scope of disaster for purposes of not asking you to sort of give up your constitutional argument, but for purposes of statutory interpretation of A? Does that fall within the scope of addressing a disaster?
I think it is a disaster or grave emergency, and I want to...
Let me follow up then. If that's a grave emergency, if it's a grave emergency to help out with tree removal, if it's a grave emergency to help out with flooding, how is it not a grave emergency to deal with a city that, one of the great cities in this country that's have a serious crime problem going on? How is that not a grave emergency?
So I've got two answers for that. First, I want to just refer to the definition of the word emergency. Now, I heard Mr. Rice make a big deal of the fact that we cited the 12th edition of Black's Law Dictionary from just the past couple of years, as opposed to the 4th edition, the contemporaneous one from 1968. I'd like to read the opening line of what the definition of emergency was in the 1968 version of Black's Law Dictionary. A sudden, unexpected happening, an unforeseen occurrence or condition. So this idea that crime prevention, which is a perpetual and continuing need in urban areas and really in any city, qualifies as an emergency, I think just runs against the basic foundational understanding. The other thing I want to emphasize here is there's a long recognition that law enforcement in particular is something that is not to be conducted by military forces, and that there's something particularly pernicious when troops patrol the streets of a city. You see that recognized in the federal context in the Posse Comitatus Act, which was adopted in the 1870s as a way of curbing use of military force. And similarly, I think the Tennessee Constitution, which was adopted in a very similar time frame, and against the backdrop of the Brownlow Guard, there's a recognition that having troops patrolling the streets is particularly problematic, and that's why
That happened after 9/11. I can remember looking out my office window and seeing National Guard troops walking around with their guns and other equipment, patrolling the streets, patrolling the sidewalks around the Capitol and other areas. So that was wrong? That was illegal?
That I think there you did have arguably an invasion. You had an emergency to the extent emergency is a sudden unexpected happening. 9/11 might be the quintessential sudden unexpected happening of my lifetime.
It certainly was for New York. I'm not sure about Tennessee.
I think at that point you'd had an attack that was launched not just on New York City. There were planes directed to Washington D.C. as well, and the scope of it was very uncertain. I don't think anything about this case affirming the judgment below does not in any way require you to say that the protecting against the 9/11.
Counsel, I want to ask you the same question I asked to General Rice. Does inaction matter here? And does that come into play? We have started in September, General Assembly's been in session, haven't taken action to endorse, embrace, or to reject. And does that come into our analysis here at all in this case? And if so, in what way?
So I think I agree with General Rice that neither the statute, that the statute doesn't specifically require that if the deployment's under 106A, either it falls within the scope of it, in which case the governor did have authority to act unilaterally, or if we're correct that the provision is best read, particularly against the constitutional backdrop, not to authorize the deployment here, then it's unlawful. I do think it's telling, though, that the governor is here, having taken the extreme step of sending armed troops to patrol Memphis indefinitely. He's done it without the backing of the legislature, which under sort of on the federal side, you would say the Youngstown framework from the steel seizure, that when you have the legislature coming in to support the executive, that's when the executive's power is going to be understood at its apex. We don't have that here. So I do think it's telling. And the other peculiarity of this case that I think was remarked on at the very start of the argument is that the governor hasn't even put his name to a piece of paper and issued a finding that there is a grave emergency in Memphis. There was a press release, and then troops showed up. But we don't
agree with the state that there is no written order here, and here I'm thinking about the 3-judge panel aspect of this, right? And so there is no written executive order in this case.
There is not.
Is that a jurisdictional question in terms of and the parties? You can't agree your way around there not being. I mean, I'm not saying there is, but that's a jurisdictional issue, is it not?
So I agree that the statute says it must go, if there's a constitutional challenge to a statute or executive order, it must go to a 3-judge panel. I don't think it would necessarily preclude this court from still addressing the questions that have been certified to it. I think 2 factors of this case underscore that. One being that this court would have appellate jurisdiction regardless of whether the case initially was heard in Chancery Court or in the 3-judge panel. This court is considering only legal questions, which it would be reviewing de novo regardless. So as a result, we think the court can and should opine on the merits, and at most, while we think in light of the parties' agreement, there is no reason to send this to a 3-judge panel. At most, what it would be appropriate to do is remand to a 3-judge panel if the court thought that there was an executive order here. But I think the parties are right that executive order has a defined meaning under Tennessee practice and law. It requires a particular document that just was never created.
I would note that the Attorney General issued an opinion in 2007 that said there's no requirement in 58.1106 that activation of the National Guard troops be preceded by a declaration of emergency by the governor. So I assume they still follow that one.
I'm not familiar with that one, Your Honor, but I will say that we haven't challenged the deployment as unlawful because there was no declaration of emergency here. We're just pointing to that as an aggravating factor and explaining why, for example, if the governor is claiming deference to his determination, while we think that would be inappropriate regardless under the separation of powers, it would be particularly inappropriate where the governor hasn't even put his name on a determination.
There is some authority that suggests that maybe the governor's decision that there is an emergency can't be reviewed. Do you have authority that says it can?
I do, Your Honor. I think there are a couple things I'd point to. First of all, just at the threshold, I want to point out that was the political question argument that the governor pressed below and did not ask this court to certify. So I'm not sure it's even properly before this court. But even setting that to the side, Tennessee courts have always, under the separation of powers, had a role in policing the outer bounds and articulating the outer bounds on the government's authority over the militia. You saw that in the Green case from the Tennessee Supreme Court in 1885. You had a Tennessee district court in 1939 note that the governor did not have authority to just send the guard out based on his own findings in ways that were inconsistent with the Tennessee Constitution. There's a long tradition of Tennessee courts fulfilling their own role under the separation of powers, and we ask that you do the same.
Thank you, Mr. Salzman, for
Thank you, Your Honors.
your comments. General Rice, your rebuttal.
Thank you, Your Honor. I'm going to try to hit a few quick hitting points. Judge Usman, I was flailing a little bit on your questions with respect to Colonial Pipeline. That's because that was not the basis on which they claimed there was a sovereign immunity, and that's because it's outside of the scope of the Rule 9 grant. So we have not briefed that, and while it's jurisdictional, so perhaps this court could still reach it, we would urge this court to express caution. Colonial Pipeline is a case that the state litigates quite frequently, and we would hate to get a bad decision on that in a case that we didn't even brief it. With respect to the proper role, Judge Bennett, that you were asking about of the courts, I want to be clear that we are not making a political question argument. Our argument is that there is a role for the courts to play. The courts should interpret the scope of 106A and determine whether the events categorically fall outside of that scope. I think our position is a more modest one. It's that if this court decides that the events at issue could possibly satisfy one of the requirements in 106A, in that circumstance, the court shouldn't be second-guessing, essentially, the governor's assessment of the facts. I kind of think of it as similar to the sufficiency of the evidence analysis, where the court interprets the scope of the criminal element and says, this is what the criminal element covers, but it doesn't second-guess the jury's determination as to whether the facts satisfy that. And that's what the Supreme Court did in Sterling. In the Sterling case, the U.S. Supreme Court recognized that the executive has the final and conclusive determination as to whether there is an exigency, but at the same time it ruled against the governor who had deployed the militia, because there he had deployed it to reduce oil production for purely political reasons, and the court enforced it. But it didn't. While enforcing it against it, it recognized that, look, we're not in the position to second guess the governor's assessment of the facts. Judge Usman, we agree that in order for there to be a right to vote, C would have to function as a veto, but I just want to add on top of that we think we win even if there was a right to vote, because any loss or any injury that is suffered would have been shared by the entire legislative body and not by the individual legislators. The U.S. Supreme Court Raines Court specifically draws a distinction between when individual legislators are singled out for specially unfavorable treatment as opposed to other members of their respective bodies.
General Rice, isn't that in the context of discussion of Powell v. McCormick, though, or the Adam Clayton Powell case, as opposed to sort of the entire context of legislative standing in Raines? I mean, I take the sentences in there, but
yes.
I think that's a reference to the Adam Clayton Powell Jr. case as opposed to necessarily the entire structure.
Your Honor, that is specifically addressing Powell. I will say, though, this is well-established law, this point that I'm making in the federal context.
We don't have to settle that, though, in terms of Tennessee Constitution, in terms of legislative standing, though. If there's no vote that's interfered with here, it's not necessary to reach whether it's whole body or individual in the context of, for purposes of how the Tennessee Constitution works with regard to that issue.
Absolutely. I'll just add that Wygant did look to some federal analogs when conducting its three-part public rights analysis. And if I could just quickly add that the federal courts, they face almost identical scenarios to what we're facing here. They've had individual legislators that have sued the president over his military action overseas.
Is it Darnell that's 2006 on Tennessee that brings in, but it didn't bring in that component of Raines. I mean, it brought in Raines, but it didn't bring in that language in terms of adoption in Tennessee.
It didn't have to, Your Honor.
Okay.
It didn't have to. I guess I'm just trying to make the point that the argument in our interpretation of Raines requiring individual legislators to be singled out as opposed to a collective injury to the body as a whole, that's been litigated numerous times against President Clinton, against President Obama. The federal courts have repeatedly rejected, and they've done so under Raines. They have construed Raines to prohibit standing in those circumstances. Your Honor, with respect to the emergency and the continual need, I just want to be abundantly clear. Our position is not that the governor can mobilize the National Guard just to stop crime. I think if the governor mobilized the National Guard and claimed that there was a grave emergency in Brentwood, I think that's a hard case to make. But when you have the most violent city in the country and you have a significant departure from the baseline with respect to crime, we do think that constitutes a grave emergency. Judge Usman, you asked about the three-judge panel and whether it's jurisdictional or not. I think in a separate case, we've argued that it is not jurisdictional. It is a mandatory claims processing rule. It doesn't use the language jurisdiction is conferred that is used elsewhere.
There's nothing in the record in this case that shows a written executive order. And so the parties are telling, I'm taking my understanding from both counsel is there's no written order and there's nothing in the record that is inconsistent with that assertion.
That's correct, Your Honor. I'd like to address, if I can quickly, the notion, you asked whether counties can sue, and in their briefing, there was an assertion that without Section 13121, that counties would not be able to sue to vindicate the local legislation clause. 13121 was enacted in 2018. There are plenty of cases where the county sued before 2018 to vindicate their rights under the local legislation clause. With respect to Judge Bennett, the questions with respect to the troops, we agree with Your Honor that 109A specifically refers to the National Guard as troops. Now, my friend keeps pointing to Perpich, but Perpich, one, involved a Minnesota statute, and the Minnesota National Guard, by statute, specifically designated the Minnesota National Guard there as the militia. So any statements from the court with respect to them wearing a state militia hat comported with the actual statute in Minnesota that designated them as a militia. I see that I'm out of time, Your Honor. Thank you, Your Honor.
Thank you. Thank you, General Rice and Mr. Salzman, for your excellent advocacy and responses to the court's question. You have assisted us in a great manner. I want to remind everyone that all of our hearings are videotaped, audio recorded, and will be uploaded on the website of the Administrative Office of the Courts if someone needs to refer to the hearing itself in the future. That concludes the docket.
All rise.